62. What does it mean for an employee to be hired at will?
Few issues cause such confusion in the workplace as the concept of employment at will. That's for good reason. Many managers believe it should say what it does, that is, allow managers to terminate employees with or without cause or prior notice. Defense attorneys who defend your company from wrongful discharge lawsuits initiated by your ex-employees employ the at-will affirmative defense to gain a summary judgment of the case. In the courtroom, your attorneys will argue that Sally Brown was hired at will. Sally understood that she was hired at will, as attested to by her signature on the employment at will agreement in her offer letter, the employment application, and the freestanding employment at will agreement in her personnel file. Your company did nothing to abrogate the employment at will relationship by engaging in oral or written contracts to the contrary. In essence, if Sally was indeed employed at will, then the merits of her case need not be heard. It was simply the employer's right to terminate her at any time with or without cause. Hence, your defense attorneys will ask for a summary judgment, that is, an immediate dismissal of the lawsuit. So where's the rub? Well, there are many exceptions to the employment at will rule, and a plaintiff attorney will argue that your company engaged in one of the exceptions, thereby abrogating the employment at will relationship. Tell me more. Without a crystal ball, you can't know what kind of spin a plaintiff attorney will place on a wrongful termination charge 2 years from now. The plaintiff attorney may argue that your company discriminated against the employee on the basis of the individual's age, race, sex, or sexual orientation. These are statutory considerations established in Title VII of the Civil Rights Act of 1964 and other legislation. Retaliated against the employee for having filed a workers' comp claim, for whistleblowing, for engaging in group activities that protest unsafe working conditions, or for refusing to commit an unlawful act on the employer's behalf. These are known as public policy exceptions. Discharged a long-term employee just before she was due to receive some anticipated financial benefit, for example, pension plan vesting. This is known as an implied covenant of good faith and fair dealing. Failed to follow promises documented in your employee handbook or verbally made during the hiring interview that required just cause to terminate. These are known as implied contract exceptions. Following are other exceptions to employment at will. Remember, it is illegal to terminate or otherwise punish an employee as a result of the individual's either doing or refusing to do the following activities, or for the employee's acknowledgement of any of these conditions. Attendance in an alcohol or drug abuse rehabilitation program. Disclosure of a condition of illiteracy. Union membership, organizational activities, or other protected, concerted activities. Wage garnishment. Filing a petition for bankruptcy. Refusal to submit to polygraph of lie detector test. Military service. Pregnancy, childbirth, or related medical conditions. Infection with HIV virus or AIDS or the appearance of physical symptoms. So here's the bottom line, without a crystal ball, you can't know what kind of spin a plaintiff attorney will place on a wrongful termination charge 2 years from now. Therefore, you can't assume you'll win a summary judgment of the case on the basis of the employment at will affirmative defense. As a result, you should assume the default, in other words, always be prepared to show cause despite the existence of an at-will employment relationship. For-cause termination is the opposite of employment at will. It dictates that employers must have a good reason to terminate and that employees should be accorded workplace due process before losing their jobs. The way employers typically show due process is in the form of written warnings as part of a progressive discipline system. After all, Many judges and arbitrators reason that if it wasn't written down, it never happened. And that's a fairly reasonable assumption on their part. If the person's performance was so bad that the company was thinking of terminating this person, then management should have at least taken the time to put it down in writing, goes the court's logic. And that's why we live with a dichotomy between employment at will and progressive discipline. It's not one or the other, it's both. This way, if you win the employment at will summary judgment, good for you. However, if the judge throws out the employment at will affirmative defense and doesn't grant a summary judgment, you can defend the termination on its own merits by showing just cause. Yes, this is a somewhat conservative approach. On the other hand, if you made all termination decisions on the basis of employees' at-will status, you'd be sailing with a loose cannon on the deck of your ship. In essence, without a consistent progressive discipline system and written warnings in an ex-employee's file, any cases that didn't get summarily dismissed would need to be settled out of court. You'd simply have no way to defend your actions.